a word of prayer. We have 1 hour. Thank you.
Hapo kwa last paragraph, I believe pursue must.
Yeah, so we have 1 hour and we would like to utilize our 1 hour appropriately. So we'll have a presentation by the corporate tribunal team, and then we'll have a Q&A session, and then we'll close the meeting. For now, I would like us to start with a word of prayer. Cynthia, would you pray for us, please?
Yes, good afternoon, anyone. Gosh, everyone, sorry, everyone. Good afternoon.
Thank you.
Sorry, I haven't had my lunch yet. I'm looking forward to lunch. Okay, we can pray. Thank you, God, for this beautiful day. And as we start our meeting, we pray, God, that you may be with us. May you guide us and may you give us wisdom. And in your name we pray. Amen.
Thank you and amen. So I believe we have the corporate tribunal team, and I'm going to introduce them. In the meantime, please feel free to put your comment or your question on the chat. We'll have a Q&A session, so we read your questions. And then after this session and within the session, feel free to share your recommendations to the Corporate Tribunal Regulations 2022. We had shared the link. If you still have a challenge accessing the regulations, my colleague Brian would share it on the chat. But now we want to go to the discussion of the day. This is a public participation forum, so the tribunal, the corporate tribunal team will take us through the regulation, and then thereafter we'll also have time for you to share your recommendations or input. So we'll share a form later in case you're not able to share during this meeting, and then ASEC will consolidate our feedback, put that into one document, and then share with the corporate tribunal team by Friday. So we need your responses and your recommendations or input by tomorrow, if possible. So allow me to invite the team, and I would like to introduce them. We have 3 members of the Corporate Tribunal Kenya. I was informed we may have the chairperson, Honorable Liz Lenjo, but I've checked and I don't think she has joined us yet. When she joins, we'll give her an opportunity. Is that the case, Helen? Yeah, I believe she may join us. So allow me to introduce, I'll introduce the 3 of them, and then I will allow them to lead the discussion. So I will start with Honorable Joseph Kihanya, who's a member of the Copyright Tribunal, Kenya. Honorable Joseph Kihanya holds an LLB from the University of Nairobi and an LLM in Media and IT Law from the University of New South Wales, Sydney, Australia. He has had training with Fahamu Oxford University in 2005, campaigning for access to information law, Oxford University in 2004 and 2009, in the Annenberg University Summer Institute in Global Media Policy. Involved in program in comparative media law and policy, PCMLP, in the United States Telecommunications Training Institute, where he got a diploma in 2014. In 10 years, Honorable Joseph has been a communication law expert. He was the head of advisory legal services in liaison with the Office of the Attorney General and responsible for leading the Ministry Information, Communications and Technology, Strategic and Tactical Legal Services, including the constitutional review processes that culminated in the Constitution of Kenya 2010, treaties, bills, acts of parliament, country positions at international organizations such as the United Nations, International Telecommunication Union, Universal Postal Union, the Internet Governance Forum, and other governmental advisory committee of the Internet Corporation for Assigned Names and Numbers. That's what we call ACANN. Joseph is the author of articles in referred journals and the Media Law Handbook for Journalists in Kenya in collaboration with Baraza Media Law Foundation. He teaches and talks on media, IT, and communications law. I had seen Joseph Kihanya, so welcome. We are very excited to have you and looking forward to the discussion today. Next, I would wish to introduce, and it's my great honor to introduce Honorable Helen Kiende Mugania. Honorable Helen is an advocate of the High Court of Kenya. She holds a master's degree in corporate law from University of South Africa and a bachelor in law LLB degree from the University of Nairobi. She is a certified public secretary and has served in various boards. She is the managing director of K&M Law Associates LLP and also a member of the Copyright Tribunal of Kenya. Welcome, Honorable Helen. We are very excited to have you and looking forward to today's discussion. And I have Honorable Caroline Omaya Bengi. Very excited, Caroline, and thank you so much for joining us. We are very glad that you supported us to have this discussion with your colleagues. Honorable Caroline is an advocate of the High Court of Kenya with 16 years post-admission experience. She holds a Master's of Laws degree in International Financial Regulation Law from Strathmore University and a Bachelor of Laws degree from University of Nairobi. Honorable Caroline is the managing partner at BMA Advocates LLP and a member of the Women on Boards Network. And she is a member of the Copyright Tribunal of Kenya. So welcome, Honorable Caroline Omaya Bengi. You will lead our discussion. So I would wish to hand over to yourself. Please advise us whether you'd like us to project the presentation or you wish to do it from we do it from our end. All right. Okay, great. So welcome, Caroline. The floor is yours.
Thank you very much, Rachel, and thank you for according us this opportunity to do the public participation through ESSEC. We are really glad that you've chosen to partner with us. So I would kindly request that you share the screen for the presentation earlier shared. And to everyone who's in attendance, good afternoon and welcome.
Ryan, do you need help? Okay. Maybe as we do that, Honorable Caroline, I would request your other colleagues to say hi, to greet us, yeah.
That's in order.
Good afternoon. My name is Helen Mungania. Yes, we are happy for you to have considered us to take you through the regulations.
Thank you for making time and welcome. Honorable Joseph.
Hello. Hello, everybody.
Hello.
Thank you very much. And yeah, let's do this.
All right, great. And thank you for making time to be with us. So back to you, Honorable Caroline.
All right, so I hope you can hear me.
Yes, we can.
Good. So the Copyright Tribunal, basically as a startup, is established under Section 48 of the Copyright Act. And just as a way of introduction on what a tribunal is, a tribunal is basically a subordinate court that falls under the judiciary. Then the tribunal has members who are specialized in a specific sector so that they are able to deal with the matters at hand. The tribunal is basically appointed by the Chief Justice of Kenya and is coordinated through the Office of the Registrar of Tribunals as established by the Judicial Service Commission. Now, the jurisdiction of our tribunal is defined under Section 1 of the Copyright Act, as read together with Section 48, subsection 4 of the Copyright Act. Should any member wish to contact us, the Secretariat is located at the Kenya Re Towers, Hill Lane, Upper Hill. We've provided our telephone number as well as our email address. Then just also as a way of introduction, we're also joined by our Secretariat members. We have Tim and we have Abdiaziz. Next page, please. So the members of the Copyright Tribunal, our chairperson is Honorable Liz Lenjo. Then we have 5 members, namely Honorable Joseph Kihanya, Honorable Helen Mungania, Honorable Wilfred Lucy, and myself. In terms of the jurisdiction of the tribunal, Section 48, subsection 4 of the Copyright Act basically outlines our jurisdiction as a tribunal, and that is to hear disputes over registration of copyright and also an appeal against the board's decision, that is the Kenya Copyright Board, known as KECOBO, where they refuse to grant a license of registration for a collective management organization and there's an issue, then an appeal can be brought to the Copyright Tribunal to determine. Secondly, where the board, that is KECOBO, gives unreasonable terms or conditions for grant of a certificate of registration to someone who's applied, then they can appeal to the tribunal for determination. Then here you have unreasonable refusal by the collective management organizations to grant a license in respect of copyright work, or imposition of unreasonable terms and conditions by a CMO. So basically, these are the 2 areas where the Copyright Tribunal has jurisdiction.
I told you, I just got it from.
Next page, please. Next slide. Now, why are we doing this public participation? The reason why we are doing the public participation is because, as I said, we are guided by the Copyright Act, and pursuant to Section 49, these regulations have been made with the objective of just outlining the procedure of the tribunal when it comes to us handling the dispute. So public participation is also required in line with the provisions of Article 10 of the Kenyan Constitution. We would therefore request that those who have already gone through, and even if you haven't finished, you can take time to then send us written comments to the email address earlier shared by 10th March 2023. Next slide. So my colleagues and I will basically take you through a summary of the various sections in the draft copyright procedure regulations. And I'll start with part 1, which deals with the preliminary. So of course, we are just dealing with the citation, which basically describes what we are doing. Then under the interpretation, we have various statutes and various definitions that have been given. The act is the Copyright Act. The board is Kenya Copyright Board, commonly known as KECOBO. Then we talk about when you're going to close pleadings. The Cabinet Secretary is also mentioned under part 1 in the interpretation section, because this is in line when it comes to appointment of the secretary who serves under the tribunal. Then we have the objectives, and basically, as I said, is just to provide a procedure of how parties are going to expeditiously come before the tribunal and discharge their duties. The guiding principles for this tribunal basically is to ensure that we provide parties with an equal platform to prosecute their case. Another important mandate of the tribunal is expeditious and fair, effective disposition of the proceedings, which basically mean, as we'll continue with the presentations, we have strict timelines that we have to ensure we comply by, so that when people come before the tribunal, then at least their matter is not dragged on for too long and they are comfortable in terms of time sought when they are looking for their orders. When it comes to the administration of the tribunal, we have a secretary of the tribunal appointed by the Cabinet Secretary on such terms and conditions as the Cabinet Secretary shall determine. In our case, the Secretary is actually appointed from the Attorney General's office, and their functions are just the day-to-day administration of the tribunal, coordination and receipt of applications of the appeals on behalf of the tribunal, and to ensure there's order and prompt conduct of our business as members of the tribunal. The Cabinet Secretary is also empowered to share and give other staff members as and when the need may be. When it comes to the constitution of the tribunal, under Section 48, subsection 4 of the Companies Act, the constitution is enumerated therein in terms of members, and it shall comprise of a minimum of 3, maximum of 5 members. Then the sitting shall be presided over by the chairperson, and in the absence of the chairperson, a member, and the requirement is that whoever is chairing a sitting must be an advocate of the High Court of Kenya. So Helen will take over and just present to us part 3, which deals with the appeal proceedings. Thank you.
Thank you very much, Caroline. I'll take you through part 3 of the regulations. Part 3 deals with the appeal proceedings, while part 4 is on the proceedings relating to compensation. Now, under the Section 48, subsection 5 of the Copyright Act, the tribunal is supposed to give the parties an opportunity to present their respective cases in person or through a representative, both orally and also in writing. So Regulation 9 is on filing of an appeal, and a person who is aggrieved by a decision of the board may file within 60 days from the date of the decision, file a notice. There's a prescribed form which is marked CT1, used for lodging an appeal, and it should be signed by the appellant and accompanied by an affidavit setting out now the grounds for the grounds that they'll be relying on during the hearing of the appeal. They should also attach a copy of the ruling of the board and other supporting documents that they'll be relying on. Regulation 10 deals with the service of the appeal notice. The appellant is supposed to serve the board with no affected parties within 1 day within 1 day. So they should attach all the documents that have been filed. The service can be done physically, that is by delivering the papers that have been filed to their last known address, or it can be done by email. Where it is done by email, it is deemed to have been served on the same day if sent during the business hours. And if it is sent outside the working hours, it's deemed to have been served the following working day. Regulation 11 deals with the response to an appeal, and the response is supposed to be done using the prescribed form CT2, and the board is expected to file and serve their response within 14 days. And they should be accompanied by a supporting affidavit and other supporting documents, which they'll be relying on. And this regulation also stipulates that a party who fails to file their response shall not be given shall not be allowed to take part in the proceedings. Regulation 12 is on submissions by the parties. The parties may within 5 days after close of pleadings in writing, file and serve submissions with the registry. Regulation 13 is on the pre-hearing conference. This one is to be held after close of pleadings, and the pre-hearing conference is meant to explore possibility of alternative dispute resolution. And it's also supposed to determine if there are documents that the tribunal may order to be produced during the hearing. It's also supposed to be a time to consider whether the parties have complied with the regulations. to identify the contested and uncontested issues, and for the tribunal to give the timetable for hearing. It is also a time to consider consolidation of the complaints or appeals, and to consider any other form of settlement. Where the parties reach a settlement, the tribunal will just record the same and delivers it as a decision of the tribunal, which is final and binding. And if the parties do not reach a settlement after the pre-hearing conference, an ADR, which is alternative dispute resolution, is not an option, the tribunal shall within 7 days from the date of the conference issue a hearing notice and set the appeal for hearing. Regulation 14 provides for the procedure during the hearing. The hearing can be done virtually or in person, save in instances where the tribunal directs that is of the opinion that the information, if disclosed, would be contrary to public interest, and also instances where disclosure of commercial information would harm the legitimate business, where the information relates to private affairs of an individual, and disclosure would harm the private individual interests. The hearing of an application for an interim order may be heard ex parte, and the appellant and the witnesses are given the first opportunity to adduce their evidence, after which they are examined by the respondent. And then once the appellants have closed their case, then the respondent will have an opportunity to present their case, to adduce their evidence together with the witnesses, and they are also examined by the appellant. The tribunal may also examine either party or witness and may call any other additional evidence it considers necessary. And the tribunal may require the parties to file written submissions. Regulation 15 is on the decision of the tribunal, and it says that the decision shall be in writing and shall be determined by a majority and read out in open within 30 days from the date of the appeal. It also provides what shall be contained in the decision of the tribunal, which includes the nature of the complaint, the number of the complaints, the names of the parties, summary of the evidence adduced, reasons for accepting or rejecting the same, and then the order and decision and reasons and reasons thereof, remedy or relief which the parties are entitled to, and then order as the cost, if any. A decision of the tribunal signed by the members of the parties should be signed by all the members of the.
Yeah.
Yep.
Okay. Sorry. That's okay. I don't want to read out the sections as what is in part 5, part 6, and part 7. Just to say that an Anton-Pillar order is an order that is ideally done in ex parte, meaning it's done by one party, so that it's like a predatory order where you make an application to the tribunal so that you can be able to go and preserve certain property from being wasted. So that when you are claiming that, for instance, somebody has copyrighted material in a certain venue, we are looking for its preservation, so to speak. So that's why an Anton-Pillar order exists. Anton-Pillar comes from a case that was determined in 1975. That's why we have that name, and we have been using it in Commonwealth jurisdictions to say that is an order that someone seeking the preservation of material that may be necessary for the tribunal to determine to have it preserved in an ex parte fashion until the hearing of the case. So that essentially is what part 5 is about. That's section 17. Part 6 is essentially about the essence of our jurisdiction. It's about the registration of copyright or the unreasonable refusal by CMO and imposition of unreasonable terms by an CMO in relation to registration of copyright. I don't intend to read the entirety of that section because I think we are running out of time. Miscellaneous provisions are there. I think part 7, and I think they are quite self-explanatory for those who have read them. So I think I would want us to save time and so that we can engage with all the people who are logged in to the session so that we can move ahead. The questions about directing our own procedure and the question about fees and the question about costs is what is contained under part 7. Thank you very much, and hoping to hear your queries or concerns.
Thank you, Honorable Kihanya, and Honorable Caroline and Helen. A very good and great presentation. I'll continue to encourage the members to share their input in the chat or your questions as well in the chat. Maybe as we wait for that, and I have also my colleague, Wangeshi, who will be coordinating our discussions on the chat. If you need any support, you need to have the link, please also put it on the chat and you'll be supported. So Wangeshi, you could say 1 or 2 things, and then I continue. I have a question I received before this session, but Wangeshi, please guide us on how the process will take place, how the public participation and them sharing the recommendations in case they are not ready today or if they are ready to share today.
All right, thank you. Let me just put my video on so at least you know you're talking to. Yeah, my name is Wangeshi Wahome. I'm an advocate of the High Court of Kenya and a patent agent, and I'm also a member of ASEC through ANZA Village. So I think the way we want to run the public participation is it's very important, especially for the different members who do either support SOs, either they are SOs supporting other founders or they themselves require these to at least understand what is required and why the copyright tribunal regulations. And so with that requires that at least we are able to understand why the regulations are there and how they affect us and where our input requires. So the regulations are not large, as they have we've seen them being taken by Honorable Joseph, Honorable Helen, and Honorable Caroline. They are not necessarily too large, but they do have an impact in our business. So why do we need responses? So that we know before they are passed, are there any changes, recommendations we can do? So we have shared a link on our chats, and it's probably the last thing that I sent. And our hope is that we can get your output either throughout the session or in the course of the day. We can probably extend receiving of your outputs until the end of the day tomorrow. I think for Rachel, that is okay. And then we can consolidate this and share them with the members of the tribunal as our own memorandum of recommendations as ASEC members. We'll also be giving responses to the chat. We'll also request our members of the tribunal to help us respond to questions that come through the chat. So we'll have responses both on the chat and people raising as we proceed. Yeah, I think ideally that's how we want to go.
Thank you, Wangeshi. So as you pick the questions from the chat, we received 2 questions before this session, and I would like our honorable members of the Corporate Tribunal to respond to them. One was around what exactly has changed, what has changed now, and then why the public participation now. The other question was, the first question is just highlighting the changes in the regulations 2022 and why the change, why the public participation now. The second question was around what we do as ASEC members. So we work with startups and SMEs, and we build capacity for them to grow, to scale, and make impact. And one of the key issue is always around IP, whether it's patent, it's copyright. And the question was, so how does the tribunal come in? How do you work with the corporate authority? You know, what is the link, and at what stage then does one approach the tribunal? Is the tribunal the court for copyright issues, or does one go to court and then later consider a negotiation through a tribunal? Maybe you could just clarify around that. Thank you. After they address the questions, then I'll allow Wangeshi to read any comments or questions from the chat. Thank you.
So thank you, Rachel. Thank you, Wangeshi, for the introduction. And just I'll take you back through the initial introduction on why do we have, why are we doing public participation? So public participation is actually regulated under the Copyright Act when you look at Section 49. And the reason why we are doing this public participation is just to engage members with a feel of how the tribunal intends to operate. For us as the tribunal know what is expected of them. So the tribunal is a subordinate court, and basically even looking at our regulations, it's a court where somebody can actually come even without legal representation. So we try to make everything simple and seamless so that somebody is able to understand what they need to do and how they are able to file the forms. That's why when you look at the regulations in the schedule, we've even attached the forms so that one is able to know how to go about it. So the issue for public participation is actually guided by the statute that before the regulations are published, then there is need to actually undergo this process in line with also the provisions of the Constitution. Secondly, regulations that usually have a time year of 10 years. The last regulations, that's why we're actually now doing these new regulations. So my other colleagues can also take up to answer the others. Thank you.
Honorable Helen and Joseph, would you like to add a comment?
Not at the moment for me.
Yes, I would like just to add that the regulations are supposed to operationalize the amended Act, Copyright Act, and public participation is a requirement even under the Constitution, where before any law is assented to, it's taken to Parliament, we are required to take it now to take part in this public participation, get comments from the people, and it's aimed at ensuring that other people, the people of Kenya, who have a right, who have a right to participate in civic obligations and governance processes, have an opportunity to give their input before we forward now the regulations, even to Parliament for approval.
All right, thank you. Wangeshi, do we have a comment from the chat?
We do have a couple. We do have two questions actually. The first one was somebody asked, what evidence do you need to endorse an Anton pillar? I think Honorable Joseph has responded to that by saying that the evidence you need on an Anton pillar order is that which shows that the subject matter under determination in the tribunal may be wasted, destroyed, and alienated. I don't know whether Honorable Joseph, you'd like to expound on that before we move on to the next question.
Yeah, essentially, that's it's directly in the regulations. It's like you're anticipating that you need certain whatever is that the subject matter before the tribunal, you need it preserved, essentially, and you fear that either it will be wasted, destroyed, or alienated. That's why you're seeking the court's help in preserving it.
All right. We do also have a question from Victor Barasa on, he says that no, he does not have a legal background, but then what is the importance of this for a founder, and how is it applicable, and how can I use this information? Probably I can just pick a bit and then I'll have one of the members of the tribunal point out. But ideally, from my point, the tribunal really focuses and the jurisdiction is really around copyright, and copyright law, just like any other intellectual property law, is actually there for any founder, any entrepreneur, any individual who has created some work around that. I think that's governed by the copyright law. And if you look at the jurisdiction given, and that was initially introduced by Honorable Caroline, what is the jurisdiction of the tribunal? It is on matters relating to either you've been denied the right to protect the copyright or for collective, the CMO processes, and CMO probably for people within the music industry and all that. You feel like you were trying to get a license or something was denied, you were given orders that were unreasonable by the Kekobo. So this goes towards either your disagreement with Kekobo versus other parties. For why is it needed for a founder? Because copyright is not actually a document for the lawyers, just like any intellectual property. It is for the founder, it's for the entrepreneur, and the lawyers are just there to help you enforce. So the founder, the entrepreneurs need to understand and protect their own innovation, their own creative rights, long before anyone else can come and do anything about it. I don't know whether anyone within the tribunal would like to add to that, especially because ASEC is supporting SMEs and entrepreneurs, and why this is important.
Yes, Wangeshi, thank you very much for the insight. So to Baraza, basically when you're thinking of a copyright, these are exclusive rights granted to various people. So it could be somebody who has done literal works, somebody who has done musical compositions, sound recordings and broadcasts, a photographer, computer-generated work. So you'll basically find that around these rights, there's also an economic benefit that accrues, so that somebody does not listen to your music or your works or whatever books you've written, then go and reproduce them and earn an economic benefit, whereas you, as the author of the works, is not benefiting from it. So that's basically where now the citizens of the state come in, because it's important for you to understand that you actually have rights under copyright, their economic rights, their moral rights, such that when somebody uses your work without your consent, then there are permissions that need to be granted. If permissions are not granted, then that would be termed infringement, and you know how to go about it. If you've gone to register your copyright and you know the license the certificate has not been granted, then you know there are avenues for you to seek to appeal. So that's where we come in as the tribunal. Thank you.
Any other question? Somebody asked to clarify on the official deadline. I think as per the form we had indicated 9th of March. And unless barring any other information, that allows us to also consolidate and share the same with the tribunal. Rachel, anything on that, or we stick to that?
Yeah. That's in order.
All right.
I can see some have joined Wangeshi after you had taken us through the input submission. Maybe you'd go through the same.
Okay.
How members can submit submissions even after this meeting.
Absolutely, I've reposted it. Yeah. As we're saying, we are going through a public participation forum for the copyright tribunal regulations. And we have the tribunal members represented here by Honorable Joseph, Honorable Caroline, and Honorable Helen. And we're very grateful to have them create some afternoon for us. And having gone through that, the regulations had been previously shared through our different platforms, including WhatsApp for people to download them. Not a large document for us to just go through them. Maybe after this, we can also share a bit of the presentation with the team. Ideally, what we wanted to get from the members of ASEC is recommendations or comments around the regulations that we just gone through. We will be consolidating once we receive the outputs. We will need to have received this by 9th of March. we've attached a form that members can use to just share the comments and recommendations. Please also do tell us why you'd want to give a comment or a recommendation, then we can be able to use that as a justification mechanism. Yeah.
Thank you, Wangeshi. Allow me, I can see we have no more questions. Allow me to give an opportunity to other members of Corporate Tribunal to say hi to us and introduce themselves. Caroline, I hope that's in order.
That's in order, Rachel.
Okay. So if there are any other members of the Corporate Tribunal, feel free to introduce yourself, please.
Good afternoon, members.
Good afternoon.
My name is Timothy. Yeah, my name is Timothy Merore. I serve as a court administrator at the Copyright Tribunal. And thank you so much, ASEC, for having us. We are truly grateful and greatly appreciate it as well. Thank you.
Thank you for coming. Do we have any other member? Okay. Seems we don't. So thank you so much, Honorable Caroline and your team for making time to be with us. We'll keep engaging yourselves. After this, we'll consolidate input and recommendations from members and other stakeholders, and then share that with you by 10th of March. Next, before we close the meeting, we would like to tell you a little bit about ASEC, because some of us are not ASEC members. So I'll take a minute. Our CEO had to dash, so she will not be with us, but I will represent her. ASEC stands for the Association of Startup and SME Enablers of Kenya. And a couple of people keep asking, so what does the association do? The association brings together and presents the interest of organizations that support startups and MSMEs in the country. And ASEC has a membership of over 70 of us. I work for Biashara Africa and serve on the board in the policy board committee. And at Biashara Africa, we work with micro and small businesses. So we support them to grow and access financing. So we are near so as per the ASEC definition. So if your organization supports startups or innovators or founders or small, micro, medium enterprises, and you're not a member of ASEC, we invite you to join the 70 plus as members in the Kenyan ecosystem. So I would like to end there. My colleagues will post our email address for ASEC, just in case you want to talk to us, or you can DM myself or any of the co-host or host. We have Wangeshi. We also have ASEC handle. So feel free to engage us. But we really invite you, if you're not a member of ASEC, to feel free to join. Our website is www.asec.ke. You can also drop us an email on info@asec.ke, and we'll be glad to engage you. And as Wangeshi has mentioned, we want to collect your input and recommendations on the Copyright Tribunal Regulations 2022. So please share your feedback on the form. We've shared the form to make it easier for you, whether you're an ASEC member or not. We'll appreciate to consolidate your input. From time to time, we keep having policy dialogues like this one. So today we are discussing the Copyright Tribunal Regulations 2022. Next, we'll also be engaging you on the startup bill and any other bill that seeks public participation and touches the needs or the work ESOs or the entrepreneur support organizations that support startups or MSME encounter. So we'll keep in touch. And if you're not on our database, please visit our website and subscribe to our newsletter so that we keep you updated. Also check our social media handles so that you can be informed of any activities or opportunities we have. Now, Wangeshi, do we have a comment?
Yes, we do. Again, I think also for the people joining us, it's important, and Victor has raised it, to know whether ASEC supports the startups directly, and what would that benefit be for the founders of the startups. So maybe we can address on who can join the membership and how that affects the founders and the startups directly.
Yeah, sure. Thank you, Wangeshi, for that. Just to reiterate what I had mentioned, ASEC stands for Association of Startup and MSME Enablers of Kenya. So if your organization supports startup innovators, they could be both in technology or non-technology businesses, or if your organization supports micro, small, and medium enterprises in the Kenyan ecosystem, then you qualify to be a member of ASEC. So tailored. I hope that answers. Happy to engage you. If you can relate to this, in relation to that question, we have 4 pillars. Let me project this. Let me project. I have seen another member of the Copyright Tribunal join. Please introduce yourself, Honorable Ali. Hello? Okay. Seems we have a
Rich, I think, are we still together?
Yes, Wangeshi.
Oh, sorry, I think we lost you for a minute.
Okay. Let me reshare. And thank you for that.
Rachel, I think we've lost you again. But we can see your screen. Rachel, can you hear me?
Oh, yes, I can hear you. Oh, you
Oh,
had lost me. Okay, it may be better for me not to project. So where did you lost me?
Actually, I think you were on mute when you were projecting, so we didn't hear anything if you were speaking.
Okay, so because of time, I'll just take.
You're on mute again, Rachel.
Okay, brings me on mute. Okay, thank you for that. So we have 5 pillars. I had talked about policy. That's why we're having this discussion. Collaboration between our members and other stakeholders, internationalization, positioning the Kenyan entrepreneurial ecosystem into the global and regional platforms. And then we have capacity building. We keep having networking and trainings in various aspects, like in the month of February and last week, actually, we had capacity building sessions around digital transformation. And then last, we have empowerment, actively facilitating economic opportunities through collaborations and our members. And wherever there are also opportunities, we extend the same to our members as well. So that's a little bit about ASEC. Yeah, so I'll stop there because of time. If you'd like to learn more or join ASEC, we put our contacts on the chat. You can drop us an email on info@asec.ke or visit our website, follow us on our social media platforms, and we'll be glad to engage you. We'll continue having policy dialogues. Next, we'll engage you on the startup bill to have your input and recommendations, and also to discuss the bill before it's passed to law. So thank you so much for making time. We would like to close the session. My colleague Wangeshi has put a form that you can use to share your input on the chat. So please feel free to share your input recommendation to the Copyright Tribunal Regulations 2022. Thank you so much for making time to join us today. Do have a great afternoon. Thank you.